the petitioner is precluded from saying that basis of decision, conflict of interest was invalid and should be set aside. We reiterate that a person cannot say at one time that a transaction is valid and thereby obtain some advantage to which he could only be entitled on the footing that it is valid, then turn around to say that it is void for the purpose of securing the same advantage. The petitioners have not questioned and could not have questioned. Rather, they have accepted the grant of one-time concession by the MCL through communication dated 12/4/2024. In our considered view, it is impermissible for them to question the decision of the MCL to disqualify them, invoking the conflict of interest clause. As has been noted herein above, the submissions have also been made with reference to past tender processes wherein MCL had not invoked the conflict of interest clause. Those circumstances similar to the present tender process did exist. Extensive submissions have been made with reference to the facts which have been brought on record by the additional affidavits. In our opinion, those facts are neither germane nor are required to be referred to and discussed on the sole ground that a decision taken in a different tender process cannot be the basis for determining the justification or otherwise of the impugned decision of the MCL in the present tender process, holding that there was a conflict of interest of BGR with NCC. Exercising power of judicial review in view of the admitted facts which have been noted above, we cannot substitute our opinion in place of opinion of the tendering authority and hold that there was no conflict of interest. The courts exercising power of judicial review have inherent limitations. We have already noted herein above the conduct of the petitioners. To avoid the consequence of their disqualification in the nature of blacklisting, and after their requests were acceded to, they continued to question the correctness of decision of the tendering authority of disqualification, invoking the conflict of interest clause. We do not approve of such conduct of the petitioner in the present set of facts and circumstances. We have rejected the contention made on behalf of the petitioners that since MCL has decided not to blacklist the petitioners and therefore their disqualification invoking the conflict of interest clause is also bad and therefore requires interference. In view of the discussions herein above, we do not find any merit in the writ applications. No interference is required with the impugned decision of disqualification invoking conflict of interest clause taken by the MCL. However, in the peculiar facts and circumstances of the present case, and in view of the nature of commercial relationship between the MCL on the one hand and NCC BGR on the other hand, we observe that the decision to disqualify the petitioners on the ground of conflict of interest has not been interfered with, and by way of concession, MCL has decided not to blacklist them. Now, since on contest, this court has declined to interfere with the disqualification applying conflict of interest clause, the MCL shall not review its decision on the question of blacklisting the petitioners on the ground of their subsequent conduct of challenging the MCL's decision before this court despite the undertakings. We further observe that it will be open for the MCL to reconsider the case of these petitioners to refund of EMD if forfeiture of the same may have the consequence of their disqualification, impediment in participation in any future tender process. These writ applications are dismissed with the aforesaid observations.
Item number 2, WA244 of 2024.
Considering the rival submissions of the parties and the facts of this case, this court is of the view that the impugned order is liable for interference and the writ application should be decided afresh by the learned single judge on merit. The order dated 6/12/2022 passed in WPC number 27479 of 2022 is set aside and the matter is remitted to the learned single judge for fresh disposal.
I agree.
Matters under to be mentioned, item number 3, W2670 of 2023.
Although this writ application had been disposed of, but while correcting the order, we felt that clarification regarding some points were necessary for which a rehearing was required. Hence, this matter has been listed today under the heading to be mentioned. The matter may be listed next week before the assigned bench for hearing.
Yes, any other urgent matter?
The losses permission, they make a mention, but I'll make a mention on 2 grounds only, Lords. One is that the petitioner, the appellant has been working as an Anganwadi worker for more than 8 years. And the writ application filed by the respondent has been allowed by the
You can make a mention on Monday.
Lords. Second thing is that, Lords, so it's a personal request. I had the privilege of appearing before Lordships on the day your Lordship assumed office in this court. So I want to take the same privilege of demit on the day your Lordship demitting office.
And who had argued the second matter?
Sorry.
Who had, you argued, you are the first person to address.
Yeah.
So who was the second person?
Yes.
So he should be given second last chance.
Nobody is there here to make that mention, Lord.
So your matter is
It's very
listed today.
difficult. Then I'll have to
The matter is listed today.
No, I want that.
give your slip.
Tomorrow. Okay. Okay.
Give your slip. Any other similar request?
The petitioner in this case has been in jail custody for 25 years, Your Lordship.
25 years.
Your Lordship, and his request for premature release has been rejected 3 times, Your Lordship.
What is his name?
Lordship, Tarkeshwar Chaudhary, Your Lordship. So may I request that matter? May be
What?
taken up tomorrow.
What is your ground? Let us understand.
For remission or what have you?
Remission.
Your Lordship, for fresh admission. Your Lordship.
No. What is on what ground?
Your Lordship, the jail superintendent has given the report that his conduct is good in the jail, but his request for premature release has been rejected 3 times, Your Lordship. The
Why?
report- Lordship, the reason given by the board is that he may conduct a crime in the future.
Must
But
be on the basis of his past conduct.
Your Lordship, but his
And
conduct,
what is the sentence?
life imprisonment.
Life in prison means what? Is it mentioned there in the order that
Yeah.
life is he will continue?
Your Lordship.
Huh?
Your Lordship, that is why,
No. What is the sentence?
Your Lordship, it is like I have not read the sentence order
Oh,
properly. Your
then
Lordship.
you
But
cannot make a mention. You cannot make a mention. If sentence can be passed to the effect that the life would mean the rest of the part of the life of a person. If that is the sentence finally imposed by the court means either High Court or Supreme Court, then the matter is different. When remission can be denied. Otherwise,
Your Lordship,
All this is criteria. Somebody like a friend.
life and the rest of the life only. The trial courts cannot impose this sentence.
Your Lordship, but prior to this, he had filed a writ petition before this.
File your,
and-
give your.
We were trying to take a chance before that, before your lordship, that matter of tender matter.
We something.
Man, it's
Both of us had appeared, man.
What is the name of the party?
It's Bartek sales matter, steel of
Steel
trade.
Authority.
It's a small tender matter.
I also mentioned last week, just to remind
It will
you.
be.
You're trying.
We know, man,
See,
it's hard pressed.
Those matters in which we could not, we are not in a position to deliver judgment, that shall be listed tomorrow for to be mentioned. We shall be releasing those matters. Of course, we are very sorry about that. Many of them were argued extensively. Because of, and we sell fixed states also.
We were actually discussing for a long time whether to mention or not to
No,
mention.
no issue, no issue.
Lest your lordship.
See, you are right. Traditionally, this was not the
This was not.
practice,
This was not.
but some of the traditions can be forgotten also. What is important is the mutual respect between the bench and the bar. That's all. So even if you say that, see, my judgment is pending for because of that, there's no difficulty. Sometimes our office fails, sometimes we fail.
No, but
There are so many circumstances.
grateful.
Though no difficulty, we'll try.
Grateful, man. Grateful.
Correction, yes, correction will.
Item number 8. Date of order is.
Copy paste it.
Item number 8, date of order 7/11/2024 has been typed in place of 7/10.
Next, item 9. The name of the petitioner is typed
The place actually, instead of
place. Bhubaneswar.
it has been typed as Nuapara.
Any other matter?
Well, item number 17, Lordship Judge for today. Yeah.
Yes, yes.
Oh, yes.
Mr. Ponda.
Mr. Panda, 17. Thank you.
Engage the council.
Discuss your last week.
Oh, we should have remembered you were appearing in another case.
Yes,
also.
yes.
Okay.
Lordship has asked for the status of the issue.
So one thing was very big asking, how many days does it normally take?
105 days.
105 days.
State expert appraisal committee, 60 days, and 45 days is the CR authority. After getting the report from the.
How many days has elapsed?
Let's say at least 28, well, let's say 24 days.
24,
Don't you expedite in some of the cases?
So the several processes, there are also four, screening is there, 5 pages, it has been specified in the EIA notification. EIA notification, they have specified. The EIA process, the C process must be gone through the screening process, scoping, public consultation, appraisal. 4 stages has been prescribed.
Appraisal, I think, can be reduced. Others, I think, will have to do. Appraisal, you will do.
No, appraisal will be expert appraisal committee.
Party.
Expert appraisal committee.
Okay.
That committee will begin and after the giving report to the CR, and then again, even the objections they will ask for clarification.
The present affidavit looks have a answer. Today they have filed an affidavit. They have
CR?
indicated in yes, CR has filed an affidavit indicating that date has been fixed on 21/1/2025 for consideration.
Do you have a copy of the
Yes.
affidavit?
So,
Has not been. It has been filed today.
yes, yes.
Yeah.
Where is this letter? 10/1/2025.
That is the email.
Can you give me?
Yes.
But I think we should notice. And you will accept the notice.
This is the statutory limitation. But they are doing it within 2 days, 3 days, 4 days, 5 days, they are doing it. This is not this is the statutory, yes, within that period they are bound to do. But they are
this is
every day
the-
they are doing
this is
within
the-
7 days, 10
This
days.
is the
15
outer
days.
limit.
And this is the public purpose, and they are strict to the time fixed in the notification.
Mr. Counsel, what you are saying may be correct,
Acha.
but on the basis of your oral submission, they cannot.
Absolutely, absolutely.
There also. Not that like this. It's all within, it's not that fixed. The outside limit has been set. What you have stated,
Yes.
in your affidavit also, you have stated within. That means the outside limit has been set.
Yes, outside limit.
So it is not that you have to do it only after
No,
105 days.
Just one thing that I point out, this you will see page 9, you will see by
Yes.
the AI notification.
Yes,
You will see by
yes.
the paragraph 7, you will see stages in prior encounter clearance process, EC process for new projects.
All that has to be followed. Like
Excuse me.
publication,
The
inviting,
right stages
objection,
that
and
is
whatever.
that's to be gone through. That has to be gone through. And that's a 60 days have been prescribed. After that, my lord, if any objection is there,
We have understood,
Yes, sir.
understood.
Yes, sir.
But that, whatever the notice or whatever, that you have to comply. That you cannot reduce.
You know, see, this much I can, submit that as far as possible, we will try to expedite things.
Yes. Because for that notice period, that cannot be reduced.
No, because
But
so,
when you say that we'll decide or appraise within so and so date, that you can.
public consultation are also there.
And for that, time is fixed, that can't be reduced. But other things you can.
This is the existing query, not that this is a new query. Since it is a existing query, so there is no difficulty in issuing EC.
Mister, if you want us to decide, we will decide it. What submission you are making, we are
On
on,
merit, we can.
today is 16th. We can hear you, we can pass appropriate orders. Also because now some stand has been taken by the estate, they are processing, maybe no order is required to be passed because of this thing. Otherwise, if you want this matter to be heard on merit, suggest us a date, we will fix it.
Because apart from this, he has stated that they will take steps to expedite.
Yes, that, that
It will be within the.
in para 4, they have stated since it was fixed to 21. Not 24.
See, at least some decision has been taken in your favor.
No,
You should be happy about that.
correct. Absolutely correct.
Yes.
Due to interference of this court only,
Yes.
I have come up to this stage.
Because we found that it was not your mistake, it was their mistake. That is why we have passed those orders. After giving it, they cancelled.
The petitioner has been awarded contract for construction of NHAI road. Which place?
Chandikol to Paradip.
From Chandikhol to Paradip. So stop.
NH 53, 53.
Bracketed NH 53. So stop. For the said purpose, the petitioner was granted quarry lease at Anjira BSQ 7.
Well, Anjira BSQ.
Yes.
Okay, for the purpose of the note. Query lease concerning Anjira BSQ 7 was allotted to the petitioner. Full stop. On the ground that the said query is situated inside reserved forest area, comma, the petitioner has been restrained from carrying out any mining activity at Anjira Mines BSU 7 Jajpur. Stop. This is the background in which the present writ application has been filed with a permission to the petitioner to operate the said Anjira Block Stone Quarry 7 till completion of NHAI Road, bracketed NHAI Road project, bracketed rehabilitation and upgradation from 4 to 8 lanes of Chandikol-Paradip section of NH 53 from 18 to 39 kilometer, ब्रैकेट क्लोज्ड, वो पार्ट पहले जहाँ लिखा है ना, इसका डिस्क्रिप्शन वही दे दो. स्टॉप. Next, during the pendency of the writ application, present writ application, and apparently because of this court's intervention, the state government of Odisha, the competent authority, has decided to allot to the petitioner an alternative site, that is Rahadpur Black Stone Quarry, bracketed 25 acres over an area of 10.62 acres, bracketed 4.297 hectare in village Rahadpur, comma, district of Jajpur. Stop. However, for undertaking the quarrying operation, the petitioner is required to get environment clearance from state level expert appraisal committee, bracketed SEAC. Stop. Next, it also appears that a recommendation has been made to the it has been sent.
On that meeting, recommendation will be made, man. On that meeting,
No, the matter has been sent to you, no?
no, not yet. On 21/1/2025 to the
21,
1/25.
25?
They will, the meeting will be held, madam. On that meeting, recommendation will be given.
Whether the matter is pending with you or not.
Yes.
It is pending before the, yes, madam. So, SEAC, State Environment Appraisal Committee, Expert Appraisal Committee.
The matter is pending before the SEAC, which is said to be under active consideration as stated in a counter affidavit filed on behalf of SIAA. Full form लिख दोगे दोनों.
In short.
Stop. In the counter affidavit filed today on behalf of SIAA, the time limit the outer time limit for grant of environmental clearance has been mentioned. First off, according to the paragraph 2, bracketed Roman 3, reads as under.
Provision is on page 13. Provision is in the page 13. Yeah, notification provision. You will see page 13, not 16.
Yes,
8-1, you will see. Roman 8.
yes.
Last, you will see. The regulatory authorities shall consider the recommendation.
Yes, within 45 days.
No, here the if 100, the you will see 45, 100, 105 days. You will see.
Where are you mentioning?
You will see in the paragraph 3, you will see page 2. Page 2, paragraph 3, you will see. As per the AI notification.
Page 2 of what?
Page 2. Page 2 of my read petition.
A counter. A counter.
You have not filed a writ petition. You are referring to paragraph page 13.
Page 13, my AI notification.
Of the
My-
annexure to your affidavit.
Yes, ma'am.
What is mentioned?
That is mentioned 105 days is the limit for.
Where is that?
Your Lordship, page 13, Lordship, paragraph.
Where is 105 mentioned?
Your Lordship, my understanding, Lordship.
Yes, tell us the page
Page
where
13,
105
page
days
13.
is mentioned.
Yes, page 13, Lordship, clause 8, Your Lordship, subclause 1. Your Lordship, may I read?
Page 13, there is no clause 8.
8, clause 8.
Just a minute.
Sub-Roman
All right,
I.
one. We are there at one.
Yes, sir. The regulatory authority shall consider the recommendation of the EAC or SEAC concerned and convey its decision to the applicant within 45 days of the receipt of the recommendation of the expert appraisal committee or state level expert appraisal
So
committee.
what is the meaning of limit and within?
My lord,
What is the limit of
Your Lordship,
limit and within?
or your Lordship,
That it
in
should
other
not take
words-
46 days.
or in other words, within 105 days of the receipt of the final environment impact
Yes, Mr.
assessment.
Mahapatra, we are telling you from the very beginning, Mr. Mishra, sorry, that the outer limit is 105 days.
Both the authority, Your Lordship, say-
So shall we record your submission that in no case you have given the
Status transfer.
approval within 105 days?
He has
Shall we
drawn.
record that?
Your Lordship, as per the statute, it is 60 days to
I am
the
asking you a question.
appraisal committee and 60.
I am asking you a
45
question.
days to the, Your Lordship, just.
Sir, we are
Your Lordship, allow-
being very, if we today, if we direct you to file a counter affidavit within 2 weeks, so you will not file that within 1 week. Because 2 weeks have been granted and therefore, and you must do it within 2 weeks, therefore, after 2 weeks, you cannot do.
Just draw the attention of the state.
We have been made to explain you this provision in such a, if it is within, then it is within. We are not asking you that you should work efficiently. You can work as leisurely as has been provided in your instruction. He has drawn our attention to the time limit in which recommendation of the EAC. EAC is Environmental Assessment Committee,
Committee. And state is the state expert appraisal committee.
is to be considered. 8 Roman 1 quote. First off. Next. In such view of the matter, we dispose of the writ application with a direction to SEIA
My lord.
to expedite the case for grant of environmental clearance as far as it is practicable. First off, the time limit with the time limit as prescribed in clause 8 bracketed 3 as quoted above is the outer time limit. First off, we are of the view that since the matter relates to construction of NHAI, which is in public interest, which work has been obstructed because the petitioner has been prevented from undertaking the querying operation at the query which was earlier allotted to it, the SIEAA shall expedite the matter and take a decision as soon as it is possible. So application stands disposed of.
On lines of development, observe that appeal permit 2 and 3, director mines and as well as collector. They also cooperate for early disposal by other clearance also.
They have already done.
No, they have not done. Subsequently, consent to operate, consent to establishment, thereafter blasting.
Other things are there.
Only by the government authority will do. So only one line observation also.
It goes without saying that the other opposite parties shall ensure expeditious what will they do?
Expeditious what?
For production.
Compliance.
For operational, my lord,
Uh-huh.
for operational.
Necessary permissions.
Yes, grant necessary permission or clearance.
Shall take all
Consequent, consequent necessary.
steps for consequent statutory permissions as and when required.
Expeditious.
Expeditiously, yes.
So which highway is that? Which highway is that?
NH 53,
Where?
Paradip to
Paradip to Chandigarh, very busiest road that in Odisha. That.
Madam, when name will be recorded.
Misra, na?
Any other matter? If it is urgent.
May item 18.
Achhi, urgent.
Attempt. Which
May-
matter? Which matter? Yes. Item 20.
Item number 20.
What was the order?
The order is my lord. That is available to my lords at page 9, last person, to comply within 3 months, my lord.
What was the order?
My lord, the order was to revive the Seva Puja of the deity, Lord Jagannath.
Revive the
Seva Puja, which has been stopped, to revive that Seva Puja within 3 months. Thereafter, they challenge review application. If I recollect, my lord, the changing advocates, they have filed a review application and my lords have dismissed the same, imposing 25,000 cost. That matter, my lord. Till now, they have not complied with
So
this.
who has to comply?
The among temple administration. my lord.
So they will have to be noticed.
Yes, ma'am, the notice have been served and they have filed counter.
The file counter.
Yes, ma'am.
Who is for the other side?
Mr. Anand Swami.
Anand Swami is not here.
He was here, but now he's not there.
All right, it will come. 2 weeks.
Next week.
Anand Swami.
Next
Sir,
week.
item number 18.
Yes.
Item number 18.
Date will be fixed or?